Good morning, everyone, and happy Halloween. You've got here Simon Kinder, partner at Bridge Law, leading the corporate and transactional practice, and my colleague Jeannie Soy of JT Esquire, also known as the Black Widow, in her
Yes.
festival outfits. A happy Halloween. We thought this would be a fun themed video for us to put together and informational. Jeannie is a founding principal of JT Esquire and an established immigration attorney helping clients from outside the US achieve their immigration goals. Today, we are going to address a very specific question dealing with L-1 visas and the overlay and interaction with US corporate law and the decisions that are made. So Jeannie, why don't you go ahead and give us a brief overview on the L-1 visa and the intent behind that?
Yeah, of course. So L1, the longer name for it is the L-1A Intracompany Transferee petition. So this petition is needed when, let's say, a company overseas outside the United States want to transfer over a key executive or a high-level manager to the United States to manage the business here. So for the first L1, generally is valid for 1 year or 3 years. To get the 3 year, the US company has to have done business or has record of doing business for more than 1 year. So sales record, contract with clients, etc. And also, if they have that 1 year of business record, the beneficiary, the person being transferred over, can also start the green card process. They may not get the green card right away, but at least they can start that process and wait in line.
Great, thank you. So that's extremely important for a situation that you and I had worked on together, where the difference between an entity already established in the US and having history here, or a brand new entity, and the impact on the length of the visa that's approved, correct?
Correct.
And so, from a corporate perspective, it's extremely important to understand the process of forming an entity from scratch in the US and where the appropriate state to do that, depending on where a person is doing business, if it's a brand new entity, or if the business already has an established entity here, how to preserve that. And so the process of preserving an entity in one state, for example, Delaware, and then wanting to operate and do business in another state because perhaps the key executive is going to work and grow that business in other states. What we would look for from a corporate perspective is how do we qualify that entity from one state to do business in another state. So in our example, Delaware to California. And typically what is required is an application is made to the California Secretary of State or other Secretary of State where the business wants to conduct its activities. And in making that application also needs to submit what's called a certificate of good standing from the domestic or home state of that entity. And that certificate of good standing is submitted along with the application to qualify to do business in the new state. And now they can continue to actively trade business there and preserve their history of the prior year. That means no need to obtain a new tax ID for federal income purposes. Granted, there are state income tax filing requirements and so on, but that is typically what we would see to help those businesses preserve their history. So we hope you found this information useful in understanding the L1 visa process, the difference between a 1 year and a 3 year, and how to qualify to do business in different states in the US. Thanks very much, everyone, and we look forward to releasing the next video post-Halloween for more information for you. Thanks very much, everyone.
Thank you.